Hello, my name is Joshua Brewster. I'm Deputy Director with the Indiana Civil Rights Commission. I wanted to today give you a general overview of our agency and how we help to enforce the civil rights laws of the state of Indiana. I'd like to begin with giving you a brief history of the Indiana Civil Rights Commission. The Commission was formed in 1961 with passage of the Indiana Civil Rights Law. Initially, the Commission had very little or no enforcement authority. Its primary focus was to conduct research and education regarding the law in the area of employment and public accommodations. The enforcement authority was granted in 1963 in the areas of employment, public accommodation, and education. Over the years, the Civil Rights Commission's authority was expanded, beginning in 1965 with the area of housing included in our laws. This was 3 years before the Federal Fair Housing Act was signed into law shortly after the assassination of Martin Luther King, Jr. In 1969, the authority was given to the director of the agency to initiate his or her own complaint without having to wait for a complaint to be filed by an individual. A few years later, in 1971, gender was added as what we call a protected class, meaning that individuals cannot be discriminated against either because they're male or female. Prohibition of discrimination in the area of credit was added in 1974. Then in 1975, 16 years before the Americans with Disability Act was enacted, disability discrimination was added to the civil rights laws. In the early 1980s, the agency created a public education and outreach unit in order to educate the public about the rights and responsibilities under the state civil rights laws. So now in 2012, the Indiana Civil Rights Law prohibits discrimination in various areas of life. We prevent discrimination on the basis of what we refer to as protected classes. All persons are covered by the Indiana Civil Rights Law, but we refer to specific characteristics as protected classes. These characteristics are race, color, national origin, ancestry, religion, sex, disability, familial status, which applies in the area of housing, meaning a person can't be denied housing because they have children under age 18. The final protected class is age, which is only covered under federal law. Some common misconceptions about what our agency does prohibit are the following. Discrimination on any non-protected basis, such as favoritism, nepotism, sexual orientation, gender identity, or source of income, for example, are things that are not currently protected under the Indiana Civil Rights Law. Additional areas not enforced by the Civil Rights Commission are union rights, wage issues, workplace safety and health, and constitutional rights. Constitutional rights could be freedom of speech, excessive police force or discriminatory arrest, free exercise of religion, and right to bear arms. These are rights that individuals have, but they're not ones that are enforced by the Civil Rights Commission. In addition to the various protected classes covered under the Indiana Civil Rights Law, our laws only apply to certain areas. Those areas are housing, employment, public accommodation, credit, and education. So we do not cover discrimination that may occur in law enforcement or other areas of life. So briefly, I'm going to go through the general overview of the various areas of enforcement that we cover. First is employment. It is unlawful to discriminate against any person with regard to recruitment, hiring or promotion, firing or demotion, transfers, training, wages or hours. Furthermore, an employer must provide accommodations for employees with disabilities or sincerely held religious beliefs. Furthermore, an employer must prevent a hostile work environment based upon an employee's sex, race, religion, national origin, or disability. The Indiana Fair Housing Act prohibits discrimination in the areas related to sale of housing or rental of housing, or even in real estate related transactions such as mortgage loans, home equity loans, or even home improvement loans. The Indiana Fair Housing Act also requires accommodations and modifications for tenants with disabilities. These could include allowing service animals or assigned parking. It could include the installation of wheelchair ramps or grab bars at the expense of the tenant. Furthermore, newer housing must have certain accessible features for people with disabilities. The law prohibits places that are open to the public from discriminating against persons because of their protected class. Public accommodations include places like hotels, restaurants, theaters, or gyms. The Indiana Civil Rights Law also prohibits lenders from discriminating against applicants in the granting of the loan, the renewing of the loan, or different interest rates for car loans, credit cards, or any type of loan. Finally, the Indiana Civil Rights Law provides that each citizen of Indiana has equal educational opportunities. This includes not having policies that might have a disparate impact on persons of a particular race or particular religion or with disabilities. Schools must also make reasonable accommodations for people with disabilities so that they can enjoy an equal educational opportunity. I would refer persons to the Indiana Department of Education for questions about individual education plans for people with students with disabilities. There may also be federal protections. So now that you have an idea of what coverage is provided under the Indiana Civil Rights Law and the Indiana Fair Housing Act, I want to take you through briefly the process that we go through in investigating a complaint brought to our agency. So any person that feels they have been aggrieved by a discriminatory practice, either in employment or housing, public accommodations, credit, or education, can file a complaint with the Indiana Civil Rights Commission. They can either call us at our toll-free number, they can contact us through our website, they can send us a fax or a letter. We will assist that person in drafting a complaint, but the complaint will have to be signed, and the complaint will need to be filed within 180 days from the time when the alleged discriminatory practice occurred. Now there is a larger time period if you're filing under the housing law, that would be 1 year. As soon as we get a complaint of discrimination in our office, we attempt to resolve the complaint short of a full investigation. We have trained neutral mediators who will attempt to resolve complaints at the outset and throughout the process. The mediator may conduct formal in-person mediation conference if the parties choose, and if a resolution is reached, the parties enter into binding settlement agreement and the complaint is withdrawn. Once we receive a signed complaint in our office, it's assigned to an investigator who will be in contact with the complainant to conduct an initial interview. A copy of the complaint will be sent to the employer or the housing provider, what we call the respondent, and they will be given an opportunity to respond to the allegations. Once that initial interview is completed, the investigator may request additional documents from the respondent. They may also want to interview witnesses. They may do additional interviews with the complainant, and they may even want to visit the place of employment or the property where the complainant lived to see if there is some additional evidence of discrimination. Once an investigator completes their investigation, they compile the evidence and draft a final investigative report. We strive to have these investigations completed within 180 days. The final step in the investigative process is a review of the file by the Deputy Director or the Executive Director of the Civil Rights Commission to determine whether there's sufficient evidence in the file to establish what we call probable cause. That means there's enough evidence that a reasonable person might think that a discriminatory act has occurred. The director or the deputy director will then issue a notice of finding to both parties, or they may request additional investigation be done. Should the director or the deputy director find no probable cause in a case, a complainant may appeal that finding to the full 7-member commission for review. The complainant should include any new and additional evidence that they may be relying on to challenge the original finding. The file would then be submitted to one of the commissioners who will review it, and they may either remand the case for further investigation, they may uphold the finding of the deputy director, or they could overturn it and issue a finding of probable cause. If the director or the deputy director does find probable cause in a case, the file would then be assigned to one of our staff attorneys. Additional efforts may be made to resolve the complaint through mediation or other settlement discussions. If settlement cannot be reached, however, there may be a need for further investigation, including formal depositions or interrogatories. Finally, the complaint would be heard before an administrative law judge. Following a formal evidentiary hearing, the ALJ will issue proposed findings to be considered by the appointed commission. Either party may file objections to these proposed findings, and those must be made in writing to the commission. The commission may choose to hear oral arguments on these objections, and after arguments are heard, then the commission will issue its final orders. They may either uphold the ALJ's findings, or they could change them slightly, or they could overturn the ALJ altogether. The final order of the Indiana Civil Rights Commission may then be appealed to the Indiana Appeals Court. Again. As I mentioned earlier, in the 1980s, the Indiana Civil Rights Commission formed a public education and outreach unit in an effort to educate the public, employers, housing providers, and others so as to avoid complaints of discrimination being filed with our agency. These outreach and education efforts may include public service announcements on radio and television, press releases, workshops and seminars, continuing legal education seminars, certified real estate instruction, print materials, and electronic communications such as emails and our website. Furthermore, the Indiana Civil Rights Commission collaborates closely with community advocacy groups such as the NAACP, the Urban League, local human rights agencies, housing authorities, disability groups, and Hispanic or other cultural groups. In addition to investigating complaints brought to our office and educating the public with regard to the civil rights laws in Indiana, the Indiana Civil Rights Commission also conducts surveys and research to determine what issues are important today. This research could include testing to uncover unlawful discriminatory housing practices. It could include surveys or inspections of multifamily housing for compliance with accessibility requirements. We also collaborate with universities and other government agencies to study disparities in education, housing, and employment. In its 50th year, the Indiana Civil Rights Commission remains committed to not only addressing complaints brought to our office, but educating the public about their rights and responsibilities and identifying the new frontiers of civil rights for Hoosiers. If you believe your rights may have been violated under the Indiana Civil Rights Law or the Indiana Fair Housing Act, please contact us at the Indiana Civil Rights Commission, 100 North Senate Avenue, room N103, Indianapolis, Indiana, 46204. You can contact us locally at 317-232-2600 or toll free at 1-800-628-2909. We also have a line for the hearing impaired at 1-800-743-OV/ICRC. I hope this presentation was informative, and I thank you for your time.